and then I'll get a list.
It's our work session on legal issues, and I see the legal team's here. Let's go ahead and identify ourselves for the record. Amy, we'll start with you.
Amy Domboski.
Felix Rivera.
Suzanne Rivera.
Bill Falsey, municipal attorney.
Barbara Jones, municipal clerk.
I'm TJ, City Council.
Christopher Constant. Weddleton.
Pete Peterson. Eric Croft.
Forrest Dunbar. Dick Trainee. Bill,
Thanks, sir.
you got the hour.
I know that you have had a long day. We're maybe close to on schedule still now, actually. But
We're on schedule.
We're on schedule. I think we can power through this fairly quickly. For the assembly members I haven't met yet, I'm Bill Falsey. I'm a municipal attorney, and there are several members of the municipal attorney office who came down to see this dog and pony show. So I'll let them introduce themselves too.
Blair Christensen. Sarah Wright. I'm Monica Elkington. I'm Dee Ennis.
Robert Owens.
So this is just going to be a whirlwind tour of what our office is and what we do, and then I'll end on a punchline of some of the bigger ticket items that may be coming to the public consciousness that you might want to be aware of. So, because we are the lawyers, we start with the language of the charter. The municipal attorney exists in the charter. The attorney shall advise and assist the municipal government on legal matters, and that means that we are not just the administration's lawyers, we're your lawyers too. And for many years, there was no regular assembly council. You are living in the halcyon days of having Dean Gates serve at your beck and call. But we too are available to you, and we're happy to work with you. So if you ever have any need, feel free to contact me or Dee, and then we will get you to the right person.
Bill, admit to the body that you cried when we got Dean to work for us.
I did curl up in a ball in my office and rock myself until I could calm back down.
There we go.
We're still in the process of trying to find a replacement for Dean. It turns out there is no replacement Dean, so we're working on it. But the code actually steps down from the charter and says a little bit more particularity what our office is supposed to do. In addition to providing legal services to the municipal government, we are to manage all of the civil litigation to which we are a party and prosecute misdemeanor criminal offenses. The way we are structured then, we are 50 people total, providing all of those functions broken into 3 branches: civil, criminal, and administrative hearing office. Upstairs on the 7th floor, you can find us in civil. We are actually 19 folks. There's a weird, quirky feature of our budget which reports me and one of the legal secretaries in a different division, which is a standalone division for reasons I don't understand. We are 19 folks up on the 7th floor. And we are 29 folks now on the 2nd floor across from the clerks who are doing the misdemeanor prosecution. There are many more folks in the criminal section, partly because of the volume of business they're doing. They do between 8,000 and 10,000 municipal prosecutions every year, broken down roughly in these proportions. You see 7,000 assaults, batteries, that kind of thing, 2,000 domestic violence, and then a small number of traffic offenses. Most of those they don't touch because they're just citations. So there's many more than 37 traffic citations issued in the municipality, but the things that are actually resulting in lawsuits are fewer and far between. The administrative hearing officer is an office of 2, so we have a hearing officer and her secretary. She sees between 60 and 125 hearings every year. Those are short of Superior Court, and they can run anywhere from child care licensing appeals and animal control appeals. There are short deadlines on all of those, and she does a sort of land office business, probably a hearing or 2 every week, and then pumps out opinions.
Is she about 32-hour-a-week employee? Or?
She's working 4 days a week now, although she's saying that in real life she may be working 5 days a week, and we should probably revisit that at some point. So we'll see what that looks like. So I'll spend the bulk of my time talking about the civil section, and there we are split among those 19 employees. We are 14 attorneys and 5 staff. We and are roughly on the attorney side split in between those who are doing non-litigation and those who are doing litigation. So on the non-litigation side, which I'm not going to talk a whole lot about, we are covering the whole canvas of the municipal government. So we have Sarah and Blair, who in their non-litigator roles, because they sort of split duty, are doing all of our collective bargaining agreements with employee relations. We have Todd Sherwood, who's handling all of our public records requests, among other cats and dogs. We've got Ralph DeWare, who works with all the utilities, helped us buy an oil and gas field last year, and is working with AWU and ML&P to sync up some of their agreements. We have a real estate person in the form of Quincy, who's helping us move all those easements you see in your packet every week, along with all the other miscellaneous land documents that you're seeing. And then before Dean left, he was part of the august crew that would process all the initiatives and referenda. When those walk in the door in the clerk's office, they come upstairs to the 7th floor. We have to decide whether they're appropriate to go to voters. On the litigation side, where I'm going to spend most of my time, I thought I would just give you a snapshot of the kinds of things that we are seeing on a regular basis. So this is a printout of our upcoming trial. There's no magic to this. This is just happens to be what's in the queue now, but it gives you kind of a sense of the various things that we're touching. So Monica is right now in the middle of Anna Nowak versus the municipality, the case of a former Muni employee who claims she was discriminated on the basis that she was Polish. She will later be going to trial on the case of Graham versus municipality, the case of the firefighter who says he was passed over for promotion because he's Korean. We have Rogers versus the municipality. I'll look this one up. This is the case of a police officer who ran into someone going about 5 miles per hour. She now says she's incurred hundreds of thousands of dollars in medical costs. Much versus municipality, a former APD officer who says that we provided some inaccurate paperwork to the Police Standards Council causing him some harm. Bernhardt versus municipality. This is the case of a public works employee who backed over a woman in a road grader. Lockhart, another rear-end traffic case. Graham, this is a flavor of litigation that we actually have a lot. This is an incarcerated individual who is in jail for a drug charge. We impounded his Escalade. I think it's a 1999 Escalade or something, and it was ultimately forfeited. He says he gets his car back, so we're working through that. AB, this is a woman who was contacted by a police officer and alleges that he used a confidential database inappropriately to find her. Janky, this is a bus that ran into someone, some sort of minor car crash. And Minor versus MOA, this is the case of the individual who died falling in the Denina Center, either, depending on your view, because he was planking on the escalator, because he jumped off the escalator, or because he fell off the escalator. No magic in any of these particular cases, but just to give you a sense of why our office is going through 100, 150 lawsuits every year. More top-line matters that might be of greater interest to you, I thought we would highlight 4 today. And so I brought Bob Owens, who, for whatever reason, seems to be saddled with a lot of our big-ticket items. And I'll pass the gavel to him and let him talk to you about the port cases, which are actually now just one case.
Yeah, singular now. The lower portion, MOA versus ICRC, and the rest of them, that litigation you probably read has all been resolved and concluded. And so we are now just dealing with the Merritt case. That's pending in the Court of Federal Claims in Washington, D.C. We do not have a trial date. It is in the middle of discovery. We've got 35 or more witnesses to depose before the end of the year. We've blocked out 2 weeks a month from May through December to do that. And that's the case that we're really expecting and intending to get some substantial recovery for the work in the future.
Maybe just for the new assembly members, this is a picture of the open cell sheet construction file. OCSP, a design that we have alleged was defective and which was inexpertly installed. The first case, which is the bottom case, was against all the private parties who designed and built the structure. We recovered just shy of $20 million from them. That has now been put to bed. And we're turning the focus now to the federal government, who is the real project manager, who gave us a contract. They said, we would deliver us a port. They did not deliver us a port.
Right. So
I've got a semi-member who's a question from Dunbar.
Actually, I think you basically you answered the first part, Bill, which is what the total settlement was. So it's about $20 million for all of that. And just again, to give our new members some scale, what's the ballpark for the settlement we're looking at from Merritt?
Damages are being re-evaluated. We've taken the position that it's about $300 million, but it's probably the provable amount and the amount that we're shooting for is significantly less, probably. So I don't know. There's a number of components. We don't know exactly what Merritt's defense is, and so How we're going to finally present the damages is a matter that's still working out.
So I think I wanted to get that out there for the new members. You're going to see some numbers of how much it's costing us, and it's pretty incredible how much money we spend on litigation. But the reason is because the potential payoff is very, very large. These are very large cases.
Mr. Peters on this issue, sir?
Thank you, Mr. Chairman. So, any estimate of how long this may drag on? Talking a couple of years, maybe?
I'm driving outside council, pushing people to keep this thing active in front burner. I'd like to see it go to trial about this time next year. DOJ is trying to push it back 8 or 10 months. That's the best guess I've got at this time.
Thank you.
Thank you. Please continue. Thank you.
Okay, so the general arrangement with this project, as Bill mentioned, is that the design is sort of unique. Those sheets in the lower portion of the picture are about 90 feet long as they go down to the seabed. At the upper portion, they're substantially shorter. The engineering and the like has all indicated that there are problems both in the design and the construction. And so the structure as it sits out there now can't stay. We're going to have to remove it. There's considerable cost associated with that, and there's some costs that we incurred in the past to get where we are. So those are two major components of our damage.
Which means that another way of answering Assemblyman Dunbar's question, how much are we looking to recover? Whatever it takes to tear the parts out which can't stay there, including a new port that actually works. All right.
Well, actually, it's not to put in the new part. Although, under a contract theory of damages, we'd be entitled to what we were expecting, but for the breach of the contract. So that's the new approach, the new background with respect to merit. The other case with the other defendants was a tort theory. We didn't have contracts with them. And so it was a claim that they owed us a duty, and we were damaged as a result of it. And part of the damage was money we would have to spend to avoid injury to others. And so the cost of taking that down was a significant component. There are overlapping, the damages are fundamentally, in the end, going to be, we don't get double recovery, but the theory is a little different, and that's why we're still refining the contract.
There are no other questions on the port. We'll keep trucking along. Another one that I think is going to get a lot of press this spring and summer is Spinard Road. So as you know, we are in the middle of a big Spinard Road reconstruction project. There are dozens of owners of property along that road, most of which we were able to come to some negotiated resolution with, but a number of which we were not.
Correct.
Quincy is not here today, so we'll keep going with Bob.
We filed 5 condemnation cases about 6 or 8 weeks ago. They kind of stretch from both ends of the project. And those were recently filed. It's a 2-step process where initially we filed a lawsuit against everybody who claims an interest in the property in question. And then at that time, we deposit into the court the amount of money we think that the owners are entitled to for their property, and we declare that we are taking. There's a brief window of time when they can object to that and ask the court to dismiss our claims. And if we get past that hurdle, then it's just a question of whether the amount we deposited into the court was adequate. So it's just a question of money. We're still at the early stage of whether the property owners are going to be claiming we have no right to take the property. And we anticipate there's going to be some pushback on the question of whether we have the right. But that should be resolved pretty quickly. And the project itself, I believe, is gearing up. It's on the street. The bids are coming in, and the contractor's going to be rolling pretty quickly. So if there's delay, time is important, but at the same time, the areas that we're trying to get control of are relatively small slivers along the road, and the work can progress even if we don't quite have control over those slivers just yet.
Just for a second, as it relates to some members, would you explain to the new members what eminent domain is? Because you came to us and asked us if we don't use eminent domain.
Right, okay.
You talk to them about that just for a second.
Under the Constitution and the Charter of the municipality, the state has delegated to the municipality the authority to take private land for public purposes. So even if the public or private owner doesn't want to give us or sell to us in appropriate circumstances and closely defined by statute, we can take the land over their objection. In this instance, it's for purposes of a right-of-way road, which is clearly one of the authorized uses under the code in the Constitution. So we worked really hard to try to work something out with all these owners. We had 85-90% voluntary coordination with them. We're able to buy property. There's a couple who believe that by taking a little piece of the road or the land adjacent to the road, their entire building and property is ruined, and they want us to buy the entire lot and their business and their building. And that's one of the difficulties where the discussions kind of got hooked on that. Others, it's just a question of how you value the property in question. But so under state law and the Constitution, you're given the authority to proceed in this fashion, and that's what we're doing, and it's just for right-of-way purposes.
Yes, Chris.
Are the costs of the taking included in the project costs or separate from?
I believe they're project costs. They're all part of the bond and overall project costs.
Anything else, Mr. Thompson? Other questions, please continue.
All right, we're going to let Bob take a seat briefly and switch to the Lieutenant Henry case, and Blair and Sarah are running point on that for us. I will say, when the legal department is generating a lot of costs, it's largely when we have to retain outside counsel for particularly complex cases. And when we spoke to you last year, we had several of those. We did Putin a lawsuit, Kennedy was not a lawsuit, Henry was one of those, the court is one of those. We're now winter now, so I think it is true that we are more or less down to just Henry and the court as outside counsel cases. But that's why we bring this one to you, because it is one of the bigger deals.
I think we've talked about this in previous sessions, that this is a case in which we did an internal investigation on APD regarding its role in the National Guard matter, and out of that came the termination of former Lieutenant Henry, and so he's suing us for wrongful termination, basically. The problem is that he's very litigious, and he has a lot of disposable income to spend in this litigation. So we've done about 30 depositions in 10 states. We're about to do expert depositions in 4 states in May. We have, for a long time, me, Sarah, and then 4 attorneys at Littler Mendelsohn have been working almost full time on this case. So we've discovered 30 to 40,000 pages of documents, and we're about docket number 530 in federal court. We filed, between the 2 parties, probably about 80 motions have been filed. So up until now, everything has been defensive because it's all been discovery. We're moving into more offensive time for us, I guess. we're filing more motions, and we're hoping to get some answers on some outstanding legal issues. But settlement has not really been an option at this point. And potentially, I think, once these motions are we kind of work through all these issues, the parties might have a more realistic expectation of what the case is worth. And so it might be an option in the future. It's hard to say.
Mr. Bowski, ma'am.
You probably may be going where I'm going to go, but I just want to caution assembly members. There are certain things that we do not discuss in open session. If it's been discussed in executive session, that's one of the things you can't talk about. So if you have questions for the lawyers specific regarding strategy, have you considered this kind of strategy? Have we done this kind of strategy? You have to be very careful, and I'm sure Bill will cut you off if you can't say
I
it.
figure Bill will.
But the lawyers are being very careful what they say because we don't want to undermine the position of the city in legal. So they're giving you the background, but if the thoughts are probably popping in your mind, well, why aren't we settling? Why aren't we this? Why aren't we that? Just know there's certain questions you can have in executive session. So if you have further questions that dive into strategy, that's not appropriate for public comment.
Yeah, I think assembly member for that, I think probably should have previewed that. We did this session in executive session last year, but I thought there was enough here that could be just digested by the public that it would be better to do it in the session. That's exactly right. Get into tactics and strategy, that would be better every single session. I think to give you a little bit of a flavor of the factual grounds here, as was reported all the way back in June 2015, this is an APD officer who we terminated and who we have said in filings was terminated in part because he revealed the identities of confidential informants during investigations into the National Guard scandal, and later because he was not truthful with an outside investigator. I brought it, included it on this list, partly because it is a case that has made it into the newspaper, unlike most of those other cases that I've showed you, but also because it really does emphasize the role that the assembly plays in a lot of this process. So we don't typically come to the assembly for day-to-day management of cases. What we often have to do is come to the assembly for approval to have outside counsel contract for certain amounts. And sometimes for supplemental appropriations, because the way the budgets are structured, legal doesn't pay all of the legal costs, the clients pay all the legal costs. So when the Henry litigation, because we're flying all over the country and dealing with a guy who's working in Iraq and making lots of money and has decided this is what he wants to do with it, APD has to find upwards of $500,000, moving maybe to even $1 million by the time this is all done, to fund this litigation. And we recognize this is just an unexciting cost of doing business. I mean, this does not get you more parks, this does not get you new snow plows, but we are trying to manage this as best we can, and hopefully the number of lawsuits that reach these magnitudes are fewer and far between. That's all I have to say about the Henry litigation.
Mr. Dyson, sir.
Unfortunately, I need to take off to go to a funeral, but I had one question I wanted to ask. I appreciate your being an attorney for the people. On the state level, the state attorney general, he's the governor's attorney, and he would and could not, because of a conflict of interest, take any action against the administration or the governor's office. I would assume you have a similar limitation.
Well, through the chair, I would say I've never given that tremendous amount of thought, and I hope it's never a situation that ever arises. I mean, my first obligation is to the client being the municipal government. I suppose if I became aware that something untoward was happening in the administration, I would probably have some responsibility to act, although I might have attorney-client responsibilities to the fact that I'm working with the mayor on a daily basis anyway. So it would be a sticky wicket, I guess, is the shortest way to respond.
Yeah.
And I don't know if this is helpful. I think it's public record now that that is not the only disciplinary action we took as a result of the investigation. There was other disciplinary action.
And I'm not speaking specifically of this, but indeed I went to 3 succession attorney generals and say, this department is not following state law. You know, will you take action? The answer is absolutely no. Conflict of interest, he represents the administration. And fortunately, you know, and it's not criminal, you know, and so on, unless you're, have standing, you can't bring suit. The legislature can, through ledge council, take action on behalf. Can the assembly, does it have standing to go into court to take action against the administration? You know?
Chair, that's not one that I've ever researched. I suspect the answer to that is probably yes. I know that we have recently had cases that were styled, at least members of the Assembly against the administration. There's a DO 37 lawsuit that I don't remember if it was the Assembly versus someone.
No,
or just
it was not the
individual
Assembly.
members. I will try my level best to ensure that we never have to figure out those kinds of questions, but I think the answer is probably there's got to be a mechanism where one branch could blow the whistle and go to court against
Yeah,
the
and please, I have nothing in mind. But it's one of the reasons why many jurisdictions elect attorney general, so that people have an advocate.
Fred, that's part of the reason we have our own attorney. As I told you before, in the Tom Fink years, you and I served together. You go to the corner of every league pin, it said TF. Tom Fink.
I remember.
Okay, that's the reason we got our own attorney. But the issue of could we sue the mayor, that's never come in front. In the 17 years I've been on the assembly, that's never come in front of us to look at that issue.
Yeah, so maybe I'd ask our attorney, are there circumstances in which the assembly could have standing in court to take action against the administration?
Well, as you pointed out, there's some comparison to the states. As you pointed out, comparing to the states of government, I think the legislative branch and executive branch can have a dispute whether they're standing. I've been here for 2 weeks now, so
Yeah. This is not the venue to answer the question.
I do think there was one case in the past, and Mr. Chairman, maybe you remember, it was about veto power. Didn't we assembly
About what?
Veto
Veto authority?
Veto authority.
I know.
D might know,
I
D.
would say there was a veto case, and there was also the challenge about moving the election date. There were two actions, the assembly versus the mayor.
Right.
And as it was, municipal council did represent the mayor on those, and the assembly got outside counsel.
That may be the answer. Yeah.
We've done that before, but you're right. But it gives Dean something to look into.
Well, and I have nothing in mind. Just
So whoever called the mayor a minute ago, would you please hang up the call? You have nothing in mind. Let's continue then.
All right.
Take care, Mr. Dyson, sir. Mr. Peterson.
Thank you, Mr. Chairman. So I was wondering, how much have we already spent on outside counsel for this case? And how much do we have that's been appropriated for additional payments to outside counsel? Does anyone know that?
Big ballpark, we spent almost $800,000. And someone had asked in the last meeting about the first quarter budget revision, we were putting another $500,000 to budget litigation. That's nice. And
That's what I was
hopefully
afraid.
they get this over the goal line. But like I say, when we have a party who feels like he has been personally wronged, and this is a matter of principle, which is always code in the legal world, but we are going to set a lot of money on fire. We are sort of playing the cards that we've been dealt with.
Okay, thank you.
Mr. Compton, sir.
So is it standard procedure then when you have a case of this nature that the cost of litigation goes to the department that was generated and not to you?
Yes.
Anything else, sir?
This brings you to my final slide, and this is not litigation, but it may be a coming attraction. And I'm not sure we have had a lot of conversation with the Assembly about this matter, but it gives you a sense of how some litigation arises at our doorstep. So,
Powerplant 2A is now functional, it's operational, it's exceeding the criteria for efficiency and the like, but in wrapping up all of the project, there has been a claim submitted by the contractor for additional compensation and additional time. The nature of the contract was what was called an EPC contract, The contractor was responsible for engineering, procurement, and construction. It was supposed to be a turnkey sort of arrangement where all of the risk, or as much as possible, was shifted to them. They got behind, they lost a lot of money on the job, and now they're trying to recover some. They found a couple of angles where they say that we interfered with their work, and they notified us and have delivered a claim actually consisting of 4 components that exceeds about $10 million. We are still in the administrative process of reviewing that claim. In fact, we've engaged outside consultant to assist in schedule analysis and responding to the claim. A lot of what they are claiming is that our actions impacted their ability to work and delayed them and cost them extra money. So we've gone to great lengths to study the progress of the work and evaluate the merits of the claim. We just received a draft of the result from our vendor, and we are prepared to respond to the claim probably within the next week. The steps of claim resolution within the contract are first that there's a project level evaluation and response. That's where we are now. So the project level people, the manager of the plant, and our outside project management consultant will evaluate the claims and respond to them. Then, if they don't like our response, they can elevate it to executive level where the director of ML&P with the chair and president of the contractor, QPG, meet and confer and try to resolve the differences. And if that doesn't work, then they're free to do whatever they think is in their best interest, which could very well be a lawsuit, or we might informally agree to do some other form of alternative dispute resolution.
But this gives me some sense of how these things wash up on our shore. And the first claim coming in is upwards of $10 million. Our consultants are telling us a different number is much closer to round figure. And whether we can get to some resolution in between there. Sometimes the larger the band, the harder it is to get to a resolution. But we will manage this as best we can.
Mr. Dunbar, sir.
So if this were to result in a non-zero settlement, which budget would it come out of? Here's my question. Could it come out of an MLP pot of money, or does it come out of the city more broadly?
It would be a project expense.
Which?
MLG.
Okay.
Mr. Rolton.
Just following up on that, so does RCA have to approve this kind of thing, or is it?
No, the settlement wouldn't have to go through RCA.
Any other questions? Yes, sir.
Does that then mean effectively that a small subset of our city's population, those who are ratepayers, to ML&P would be paying for the cost of the settlement?
How that translates is uncertain. I know that the project itself, the capital funding for the project, may have resources for handling some of this. Whether it would then, depending on the outcome, worst case scenario, translate into some sort of impact on rates, I don't know. I have to go through the RCA.
Any other questions? Thank you. Anything else, Bill?
No, that's it for us. Hopefully we've gotten you a little ahead of schedule.
Any overall questions from the open assembly? Thank you for your time. Appreciate it. On our schedule, the next one is SAP update, which is supposed to be at 2:15. I don't think they're in Spear right now, so we'll take a few minutes break. And I'll start the meeting again at 2:15.